the Auditor General wants to do his job, but a Minister of Finance will not facilitate that. So, and Madam Speaker, those royalties have, I know it sounds like a small number, but I know those royalties in the past have represented about 2% of the province's revenue. And we talk about balancing budgets, and we talk about a government that's raising taxes, HST being one notable, to increase revenues. Well, royalties from our oil and gas are a significant component of revenues for the province. Why isn't the Minister of Finance making sure that we're getting our fair shake? Madam Speaker, how much time do I have left?
Just over 1 minute.
Okay. I'm going to have to move ahead a little bit here. So I think to wind down, we believe that the Auditor General is correct and that the Minister of Finance should change his position on this matter. How can the Minister stand with the Auditor General when he says things that he agrees with, but stand against the Auditor General if something comes about, like this situation, where the Minister disagrees with the Auditor General? It is wrong to stand on the sidelines and wait to see what a court will direct. This is not a theoretical argument. The Offshore Petroleum Board regulates health and safety of our workers, protects our environment, and of course looks to make sure that our royalty rates that the province is getting are accurate, that we're getting our fair share from the industry. It is in the public's best interest to know that these functions are being performed adequately. If they are not, that action is being taken. If they are not, and action is not being taken to protect the environment or the petroleum resource stakes that we deserve, then the Auditor General I think I'll wrap it up by saying that our caucus is urging the Minister of Finance to take action and play a leadership role to ensure the resolution of this dispute between the Auditor General and the Offshore Petroleum Board. Thank you, Madam Speaker.
Thank you. I recognize the honourable member for Halifax, Chebucto.
Thank you very much. This entire issue is a discussion for lawyers. Now, we can have the discussion here, and to a certain extent we will, but really it should take place in the courts. The courts are the best place to resolve all of the issues that have been identified in this motion and have been identified in other discussions that have been associated with the issue. There is an ambiguity in the resolution that has been put forward that has not been resolved by the comments of the previous speaker. The resolution says that the Minister of Finance shall take leadership on this important issue. Now, there are two possible interpretations of that resolution. One is an active interpretation, and the other is a passive interpretation. The active interpretation would be that somehow the Minister of Finance has authority to resolve this issue. Somehow the Minister of Finance has powers over either the CNSOPB or the Auditor General, or both of them. I assure the honourable members that this is not the case. In no respect does the Minister of Finance have any powers with respect to the CNSOPB, and in no respect by any means does the Minister of Finance have any powers or any authority with respect to the Auditor General. Members will know that the Auditor General is an independent arm's-length functionary. Under Section 3 of the Auditor General's Act, the Auditor General is an officer of the House of Assembly. He is not a member of the government staff. He is not a member of the Minister of Finance's staff. The Minister of Finance has no authority, nor does any individual member of this House have any authority to tell the Auditor General to do anything. It's entirely up to the Auditor General to decide what powers he exercises within the confines of the powers granted to him by his statute. He gets to decide who he audits. If it's an auditable entity, all of those powers are there to maintain his independence, which is something that we all agree upon. But the Minister of Finance has no powers at all to order the Auditor General to do anything, or to think anything, or to resolve any issue. That's the active interpretation of the resolution. If the passive interpretation of the resolution is what's intended, that is to say that the Minister of Finance should make useful and helpful suggestions to the Auditor General, then in fact the Minister of Finance has already done that. The Minister of Finance has stood in this House during question period and said several times that what should happen is that the CNSOPB and the Auditor General in the public interests should get together and resolve their differences on this point of access to information. And he has said further that there are abundant powers inside the Auditor General's Act that allow this matter to be resolved. And he has urged the Auditor General to use those powers. Therefore, the Minister of Finance, on the passive interpretation of this resolution, has done exactly what it is that this resolution asks him to do. He has made useful suggestions. Let's remind ourselves of exactly what it is that has occurred to lead us to this point. The Auditor General has power to audit any auditable entities. The CNSOB is certainly one of those entities. He tried to do a full audit of the CNSOPB, but he was not given full access to documents. And the reason was the CNSOPB decided that Freedom of Information and Protection of Privacy legislation apparently applied. They referred to what they called third-party privileged information, and therefore they did not allow the Auditor General to have full access to the documents that the Auditor General was interested in seeing. As a result of this, the Auditor General abandoned his audit and reported this in his interim November report. A very straightforward history. However, the question then becomes, what might be available to the Auditor General in these circumstances when he finds himself to be frustrated in his access to documents? This dilemma has been anticipated by the specific terms of the Auditor General's Act, and provisions have very wisely been made in the legislation that tell us what it is that can be done to resolve this issue. And I recall specifically that in question period, the Minister of Finance directed the attention of members of this House and of the Auditor General to the specifics of Section 14 of the Auditor General Act. And what he said there was he quoted the section that said that where the Auditor General and the auditable entity are unable to agree as to what records are privileged records, either party may make an application to the Supreme Court to determine the matter. That's clear. But you know what? It turns out that that isn't the only power that the Auditor General actually has in the Act to deal with access to information from an auditable entity. If one goes back earlier in the statute and looks at Section 11, Section 12, and Section 13, you will find that the Auditor General has the powers of a judge of the Supreme Court to require any member of the audit or staff of the auditable entity to bring documents to him. In other words, he basically can issue subpoenas on his own, something known as a subpoena duces tecum. Come personally and bring your documents with you because we want to see it. That's a plenary power. That's an amazing kind of power, but the Auditor General has it because, as I said, this legislation anticipated the possibility that there might be difficulties on the part of an auditable entity. Furthermore, he can require any person to provide evidence, testimony, or information under oath or provide documents respecting the matter under question and may issue a notice requiring such attendance or evidence. And again, you can go to court in order to commit the witness for contempt, if that in fact is a problem. There are abundant remedies available to the Auditor General when this kind of dispute is encountered. And in fact, as I read the documents that the Auditor General supplied, he was frustrated in his opportunity to have access to the documents back in September, and his report didn't come out, as we know, until last week or so. So there were 2 months there in which the Auditor General might well have exercised those powers. For whatever reason, the Auditor General has chosen not to exercise those powers, and the only indication that we have as to why that is that the Auditor General seems to think that it would be expensive and protracted to have a fight in court about his legal powers. Well, I have to make the following observation. Because the Auditor General has these powers, there are monies in his budget that would allow him to do this, and I should point out for all the members here and for the Auditor General that such disputes don't have to be protracted. There are 2 kinds of litigation, broadly speaking, that go to court. One is what's called an action, and one is what's called an application. An action is where the facts are in dispute and where there might be a long trial and the veracity of witnesses has to be assessed by a judge, and there's back and forth and there's discovery, and it goes on, and that can be long and protracted. But that isn't this kind of issue. The kind of issue that the Auditor General is dealing with is what's called an application. In an application, the essence of the question is not a dispute about facts, but a dispute about a point of law. The facts are not generally questioned. And here, that's exactly what we're looking at. People don't dispute what the facts are. The Auditor General wanted the documents, the CNSOPB said no, and the issue revolves around, just as I said at the beginning, a point of law that's good for discussion by the lawyers but should be resolved by the judges. This is exactly what should happen. There should be affidavits filed in court, and the judge will decide the point of law. It's a very simple and straightforward process, not expensive, not protracted. It's exactly the kind of thing that the legislation anticipated, and it's exactly the kind of thing that the remedies of the statute have addressed. So what I think can be said about tonight's motion is that it is simply misconceived. If it's based on the idea that the Minister of Finance has authority over the Auditor General, it's simply mistaken. If it seeks the Minister of Finance giving good advice to the Auditor General, that has happened. Thank you very much, Madam Speaker.
Thank you. I recognize the honourable member for Preston.
Thank you, Madam Speaker. It's quite an interesting topic, this, and I appreciate the two previous speakers and their views on this. And it's one that I've witnessed before when this government was in opposition, actually by the finance minister. I remember in one committee I was chair of, Economic Development Committee, there was a big issue whether the Deputy Minister of Finance should provide information to the committee. And indeed, we went through a long, prolonged, protracted system to try to come up with a solution for that, and at the end of the day, we didn't get it. And the now Minister of Finance was very upset about that, and rightfully so. I was also very upset about it. Since then, the Auditor General has also refused the right to acquire certain information that he had required for doing audits in the process. So when this government came to be, they decided, as I'm sure anybody else who would have got elected would have amended the Auditor General's Act to allow the Auditor General to have more broad and more power to actually audit the books of the province, just to ensure, absolutely to ensure, that the information that the departments were providing, or staff was providing, or the minister's office was providing, whatever it might be, or a Crown Corporation might be providing, is accurate. And indeed, that the money that they're allotted by the budget here in the province and the money they have to operate is well spent. Not only that, but the departments are well managed. And indeed, the safety of Nova Scotians are not at risk. And I believe our Auditor General does a good job of that. There's always some debate when the time comes whether a department believes the Auditor General or agrees with what the Auditor General has done or is saying about their department and what's going on. But fortunately, we have an audit system. And unfortunately, in this case, the same finance minister was so adamant about having full disclosure to the Auditor General, didn't have enough faith in the Minister of Natural Resources and Minister responsible for energy to answer questions in this House. He didn't have enough faith in one of his own ministers who this Nova Scotia, Canadian Offshore, Nova Scotia Petroleum Board is under. That's the person that should answer the questions in this. And indeed, when the finance minister basically, it appeared like, from where I'm sitting across the floor, that the finance minister said to him, basically, you know, I'll handle these questions. I can capably handle these questions. Made it look like he didn't feel that the Minister of Natural Resources had the ability to answer the questions. Now, I would assume that the minister did. It's in his responsibility to do this. And indeed, the people in his department, when the response to the Auditor General indicated indeed this could be resolved. It could be resolved without going to court. My honourable colleague from the NDP that just spoke indicated that, you know, this wouldn't be too expensive. Probably not. Maybe it would be. Maybe very, very, very expensive. You're dealing with oil companies here that have, as compared to Nova Scotia, unlimited resources. We don't have resources. It'd be better if we spent our money on job creation and to help the serious problem we have with the 12,500 people that have lost their jobs in Nova Scotia since the NDP government made this better deal for today's families. And it would be better if the government would come back and make an amendment to the Act, if indeed that's what they do, and we would agree with that, I'm sure, and I'm so sure with the third party would as well, to ensure that the Auditor General has the power that he needs to audit this particular board. I can also understand some of the issues that the Canadian and Nova Scotia Offshore Petroleum Board may have with sensitive information that is there, and I'm sure with the right kind of an agreement with the Auditor General, that could be addressed when it's in the interest of the province to do that. But again, you know, the solution is go to court. Go to court. Hopefully not everybody in this province has gone to court, but I can tell you I've been to court a few times and it's extremely expensive. The outcome is never sure. You're never sure of the outcome. It doesn't matter what happens. You can have a rock solid case, it appears, and at the end of the day your case isn't that good. Or the judge feels it isn't that good. That's really what the case is. The judge doesn't feel it's that good and you lose. So you've lost all kinds of time, money, effort, and everything that goes with that. We don't need to be going to court in this province so we can avoid it. It could be simply an amendment to the Act, give the Auditor General the responsibility and authority to do that, and if that's the case, that's what we should do. Now, we'd have to seek advice from the legal counsel in the province and see if that can be done, but I'm sure it can be. So the point comes down to, we have a Minister of Finance that says, go to court. Go to court. That's his answer right away, go to court. And that sounds okay sometimes, but why spend taxpayers' money? When the same Minister of Finance, when he was in opposition, was saying the Auditor General should have all these rights. So there seems to be a paradox here that things have changed. So when that honourable member became Finance Minister, when he was in opposition. And this is a continuous trend. Maybe he realized now that he's in government that there's a whole lot different reality in being in government than there is in opposition, and you're promising everything under the sun and not being able to deliver it. And again, the same as the deal at the, you know, better deal for today's families that was promised by this government. And indeed, it's I don't know if it's a better deal or not, but it sure doesn't seem it. And as more and more people are unemployed in this province, I think they're starting to realize that it's not a better deal for them. And as time goes on, I think that situation is going to get worse as taxes increase and all the other costs increase. So when you come back to this and you look at this answer that this government has, go to the Supreme Court, fight it out in the Supreme Court. Yeah, sounds simple, sounds easy, but who's paying the bill? The taxpayers of this province. We're already paying way too many taxes in this province, way too many. We're not competitive here anymore. We're not to a point in this province that we can attract business. And it's showing in the numbers. It's actually showing in the numbers now. And when you look, we had the worst gross domestic product improvement in this province in the whole country. And when our taxes are the highest in Canada, that means they're the highest in North America. The highest in North America. So why would someone want to come here and set a business up and operate in Nova Scotia? No, it's a beautiful place to live. We got really hard-working people. We get very dedicated people. But all those people are getting smart, and they're deciding not to live in Nova Scotia because of the high taxes as it goes on. And then the minister comes along and says, well, let's go to court, spend more money. We can spend more money. We've got all kinds of money. At the same time, we don't have enough money to fix our roads. We don't have enough money to do all the things we need in education. We don't have the money to do anything that we really need to do. And then if we spend a lot of money going to court, could be $5,000, could be $100,000, could be $500,000, who knows? When you go to court, you're up against some pretty strong people when you take these oil companies on. And I can tell you, they have the financial resources and they have the best lawyers in the world that can fight this. and work on this if they figure it's a strong enough case they would have. And they would use every legal trick in the book to ensure that indeed this was drug on for a long, long time. And anyone says, oh yeah, it's really simple, it's not expensive. Well, I think as this would unfold, it would be very expensive. And the Minister of Finance and this government might decide at that point they made a huge mistake and better put legislation in place. And I'm not sure if the legislation would overrule a court case or not. Probably wouldn't. Once it's agreed on, who knows? We'd have to check with people in the legal field and see if that's indeed the case. But anyway, no matter how this is done, the Auditor General should have the right to audit any department in this, any organization that the province puts money into. It's that simple. There's no other way to describe it. It's just simply that important that happens. And if that doesn't happen, and the answer we get from the Minister of Finance, who doesn't have any faith at all in his Minister of Natural Resources and the Minister of Energy to answer questions, none. So how can we expect to have any kind of a process in place that will be fair to Nova Scotians? I don't think there is. And unfortunately, we're in a deadlock that we should not be in. The Auditor General should have the right to do this automatically. And indeed, if we need to adjust or change the law, we need to change it. We need to do it now. Thank you very much.
Thank you. The time allotted for late debate has elapsed. I want to thank all members for participating in tonight's debate, and we stand adjourned to rise again tomorrow.